Swayam Prabha. Digital India. Educated India.
Section 12, Examination of Application. 12.1 states that where a request for examination has been made in respect of an application for a patent in the prescribed manner under subsection 1 or subsection 3 of section 11b, the application and specification and other documents related thereto shall be referred at the earliest by the controller to an examiner for making a report to him in respect of the following matters, namely. So, once a request for examination is made, the controller shall refer at the earliest to an examiner based on the examiner's expertise in the domain to make a report back to the controller on the following matters. So, this is called the examiner's report. The examiner makes a report to the controller and the report pertains to the following matters. There are 4 things. A, whether the application or specification or other documents thereto are in accordance with the requirements of the Act and the rules made thereunder. Procedural compliance with the Act and the rules, that is A. B, whether there is any lawful ground of objection of the grant of a patent under this Act in pursuance of the application. Lawful ground of objection are objections, we understand this as objections based on patentability, objections relating to section 3 and 4, which are exceptions to exceptions that which gives the statutory exceptions as to what are not inventions, and they could also be objections pertaining to satisfying the requirements of a complete specification, which are largely mentioned in section 10. So, the lawful objection could come from a provision of the Patents Act which requires the applicant to satisfy those provisions. In the absence of the applicant not satisfying these provisions, they could be construed as an objection for the grant of a patent. So, while A talks about requirements under the Act and the rules, that is whether the application, specification and the documents wherein there is a requirement that a particular margin should be given for the complete specification, drawings should not have writings within them except in the case of flow diagrams, claims should start in a separate sheet. Now, these are all requirements that an application has to satisfy under the Act and the rules, and the timeline requirements, the fee requirements, these are requirements under the Act and the rule. Lawful ground of objection could be an substantial objection, not a procedural objection, substantial objection for not granting a patent. For instance, lack of novelty, the invention does not have novelty, or the invention does not involve an inventive step, the invention is obvious to a person skilled in the art. These are lawful objections because a patent office cannot grant a patent over an invention which is obvious to a person skilled in the art. So, these objections are termed as lawful ground for objections. C, the results of investigations made under section 13, we will see in under section 13 the examiner shall make a report on anticipation. It is largely a novelty report. So, the search for anticipation is done by the examiner and the result of the investigation is communicated to the controller. So, the examiner also gives in a report on the search, it is a search report, search on anticipation, and D, any other matter which may be prescribed. So, the examiner has to look into these 4 things and make a report on these 4 things to the controller, and the report that the examiner makes to the controller shall be confidential. Section 144 states that reports of examiners to be confidential. The report of examiners to the controller under this act, which is made under sections 12, shall not be open to public inspection or be published by the controller, and such report shall not be liable to production or inspection in any legal proceeding unless the court certifies that the production and inspection is desirable in the interest of justice and ought to be allowed. So, the normal rule is that the report made by an examiner to the controller under section 12 is confidential. And this report is not the first examination report or the first statement of objection, because based on this report the controller will issue the first statement of objections or the first examination report. So, it is easy to get misled by the fact that the examiner's report is the first examination report. It is not so. The first examination report is issued by the controller, whereas what is issued by the examiner is an internal document which goes to the controller, based on which the controller makes his first examination report. So, the first examination report is not the report made by the examiner to the controller, rather it is a report that is issued by the controller, and now it is called the first statement of objections. Section 12(2) says that the examiner to whom the application or the specification and other documents relating thereto are referred under subsection 1 shall ordinarily make the report to the controller within a period as may be prescribed. Now, this is just the internal procedure. Once the file or the specification, the application and the documents are referred to the examiner has a time period within which he shall make his report. That time period we will see will change based on the nature of examination. If the examination is an ordinary examination, then there is a time period for that. If it is an expedited examination under 24C, there is a different time period for that. So, we will just see the corresponding rules now. Rule 24B2 Roman 2, the period within which the examiner shall make the report under subsection 2 of section 12 shall ordinarily be 1 month, but not exceeding 3 months from the date of reference of the application to him by the controller. So, the examiner, once the reference is made by the controller, has to make this report within 1 month, but not exceeding 3 months. So, the examiner has 3 months to make this report under section 12. 3 states that the period within which the controller shall dispose of the report of the examiner shall ordinarily be 1 month from the date of receipt of such report by the controller. These are all timelines by which the application moves within the patent office. Once a request for examination is made, the controller shall refer the matter to the examiner. Section 12 does not give a timeline for the controller making the reference to the examiner. It merely says at the earliest. So, section 12, so the first thing that will happen after the request for examination is made is that the controller will refer the matter to the examiner. What is the timeline for that? The act does not say any timeline, it merely says at the earliest. So, the controller makes the reference to the examiner. Once the examiner receives the reference and the files, the examiner shall file his report between 1 to 3 months. So, that is a timeline for the examiner to file the report, which is a confidential report, back to the controller. Once the controller receives that report, the controller shall dispose of the report of the examiner within 1 month from the receipt of such report. So, the controller has to act on the report within 1 month of receiving it. Now, what does the controller do? Rule 24B3 tells us that the first statement of objections, along with any document as may be required, shall be issued by the controller to the applicant or his authorized agent within 1 month from the date of disposal of the report of the examiner by the controller. So, the report of the examiner has to be disposed of within 1 month of receiving it, and within 1 month from the date of disposal, the controller shall issue the statement of objection, the first statement of objection, which was earlier called the first examination report. It is now called the first statement of objection. So, the controller shall issue the first statement of objection within 1 month of disposing of the report of the examiner, and this is issued to the applicant or the authorized agent of the applicant. So, now we are able to see the timelines. Request for examination is made within 48 months of the date of priority or from the date of filing the application in a normal case. Once the request for examination is made, the controller at the earliest possible time refers it to an examiner. Now, there is no timeline mentioned on the act, it is just said at the earliest occasion. It is not, the time is not prescribed. So, that is one part in the prosecution where there is no prescribed time, where the controller refers the application to the examiner. There is no time prescribed, it is just mentioned at the earliest. Once it is referred to the examiner within a period between 1 to 3 months shall file his report back to the controller. When the controller receives the report, within 1 month he shall dispose the report, and from 1 month of disposing the report, the controller shall issue the first statement of objections to the applicant or the agent of the applicant. So, this gives you the timeline of what happens once an request for examination is filed. Sub-rule 3 of Rule 24B states that provided that where a request for examination was filed by a person interested, only an intimation of such examination may be sent to the person interested. Now, we had pointed this out as an anomaly. A person interested does not do anything in prosecution except that he gets the power to initiate the examination by filing a request for examination. We had already pointed this out to you that a person interested could be a person who has a competitive interest or an affirming interest or an interest in the patent itself, either as a person who acquires an interest later on, and when he makes a request for examination, only an intimation of such examination is sent to the person interested. The first statement of objection is not sent to the person interested, only an intimation is sent. So, this clearly states that the applicant is still the person who gets to drive the examination process, because if the applicant does not do, assume that the first statement of objection is issued and the applicant does not proceed with it, he does not reply to the first statement of objections within the timeline prescribed, again the patent application will be deemed to have been abandoned. So, though one of the reasons for giving the right to initiate an examination or to initiate or file the request for examination could be that upon failure to file the request for examination, the application will be treated as withdrawn by the applicant. Whereas, when a request for examination is filed either by the applicant or by an interested person, and then the applicant fails to respond to the first statement of objections, the application will be now treated as something that have been deemed to be abandoned. So, the law uses two different phrases where there is inaction by the applicant, in that the applicant does not make a request for examination. The law treats the application as withdrawn by the applicant, whereas if the examination proceeds and the first examination report is filed by the applicant, and the first examination report or the first statement of objection is filed by the controller, the applicant does not respond to that, then the applicant is deemed to have been abandoned. Now, we get this from the language of section 21, and when we deal with section 21, we will see the difference between instances where something is deemed to be withdrawn and instances where something is deemed to be abandoned. 24B4 states that a reply to the first statement of objections and subsequent reply, if any, shall be proceeded. Section 24B4 states that a reply to the first statement of objections and subsequent reply, if any, shall be processed in the order in which such reply is received. Because patent prosecution is a process which happens for multiple applications at the same time before the patent office. The patent office will only deal with things in the order in which the reply is received. So, your date of filing the application, your date of filing the request for examination are not relevant when it comes to replying to the first statement of objections. So, whenever the reply is it will be in the shall be processed in the order in which the reply is received. For instance, if the applicant files a reply to the first statement of objections within a week's time of receiving the objections, his application will move forward based on the reply received. If the applicant prolongs the reply and waits till the expiry of till 1 week before the expiry of the period and then files it, then it will be processed in the order in which the reply is received. So, again the pace of prosecution is determined by the action of the applicant. If the applicant moves quickly, the prosecution is likely to move faster. If the applicant moves slowly, then the prosecution will move in the order in which the reply was received. So, again the burden of moving the prosecution quickly is partly shifted on the applicant. Subrule 5 says that the time for putting an application in order for grant under section 21 shall be 6 months from the date on which the first statement of objection is issued to the applicant to comply with the requirements. Within 6 months of the first statement of objection being issued, the applicant has to comply with the requirements. Now, is the 6-month period a period that is set on stone, in the sense that if you do not reply within this period, or if you reply within this period and your reply is not perfect, will you get an additional period beyond 6 months, or in other words, can the 6 months period be understood as a 6-month period for a reply for the first statement of objection, such that any further statement of objection that follows through it can go beyond the 6-month period. Now, there are two ways to look at it. If you look at the next rule, that is rule 24C, which talks about expedited examination, and compare it with this provision, you may get an impression that this is an open ended timeline. The time for putting the application for a grant under section 21 shall be 6 months from the date on which the first statement of objection is issued to the applicant. Now, when I say it is an open timeline, it could be construed as you need to respond to the first statement of objection within 6 months, and any further responses can have its own timeline. It is not that all the objections have to be complied within the 6-month period, because we could get this impression when we look at the language used in the next rule, and we will compare that when we come to expedited examination in 24C. So, the 6 months period can be understood as the 6 months within which you respond to the first statement of objection, and if there are further objections based on that, it could be argued that you can go beyond the 6-month period to address those issues. It is a matter of argument. The other way in which this provision can be interpreted is that every objection that comes out of the first statement of objection has to be addressed within the first 6 months of the date on which the first statement of objection is issued. There will be a strict interpretation of the provision, and patent applicants are likely to have issues in prosecuting applications if a strict interpretation of this provision is applied. 24B6 states that the time for putting the application for grant under section 21 as prescribed in sub rule 4 may be further extended to a period of 3 months on a request in form 4. Form 4 is a general form used for any extension of time along with the prescribed fee made to the controller before the expiry of the period under sub rule 4. Now, you could extend the time for filing a reply, which is normally 6 months, before the expiry of the 6 months, provided you make a request for extension of time under form 4. You can seek an additional 3 months. So, 6 plus 3, whether you can file further form 4s one after the other and extend the timeline is debatable, but the sub rule 6 tells us that before the 6 month period expires, you could file a further extension of 3 months. So, on paper you could say that prosecution, the entire process of objections of replying to the first statement of objections has to be complied within a maximum of 9 months. You could say this by an interpretation of sub rule 4, 5 and 6 put together. You could say that the patent applicant has to respond to all the objections that have come in the first statement of objection within a period of 9 months. And recently we had the Minister of Commerce make a statement that the applications will be examined within a smaller time frame than it was done before, and we should be able to have grants within 18 months of the start of the prosecution process. So, there was a policy which the Indian Patent Office is now moving towards to expedite the grants. So, this provision could be seen in line that if the applicant can only take time of up to 9 months for addressing the first statement of objections, then obviously the process of grant is going to become much quicker.